Good afternoon, everybody, and welcome to the final session that we have today, the final of our 6 sessions that we've done covering risk and resilience in organisations. So we started the day talking about general risks, and we're going to end the day talking about one of our favourite topics at Risk Evolves, the GDPR. I've been joined by 2 colleagues. I've been joined by Anna and Andy. For those of you that haven't met them before, I'll let them do a really quick intro. Anna, who are you? What are you doing here? What's your role?
Good afternoon, everybody. My name is Anna Walters. I'm one of the senior data protection consultants here at Risk Evolves. I've been in data protection for a long time, longer than I care to think about. The way I would describe myself really in terms of how long I've been doing it is I'm older than the internet. So that gives you a little bit of a clue. And I joined the Risk Evolves team nearly 12 months ago now, Helen, it is. That's,
gosh,
you know,
it's
gone very quick. I know. But I've known the Risk Evolve team for a good few years. So that's me. Hi, everyone.
And Andy?
Yes, hi, everyone. So I've been with Risk Evolve now for probably around about 5 years, I guess. So probably one of the first to join, and pretty much my whole journey with Risk Evolve has been around GDPR and helping clients make sense of stuff that they probably didn't understand 3 years ago, that let alone is continue to evolve, they don't understand now. But I guess my background was working in Lloyd's, and I'd always sort of got a reputation of solving problems, helping fix problems. So I think even when I've left and joined Risk Evolve, I'm still doing that, helping clients fix a few problems or gaps they've got in what they do. Yeah, so it's all good fun, and obviously
absolutely. So thank you for that, guys. Just for those of you who haven't been with us throughout the day, so apologies for those that have been with us. I'm just going to go through the housekeeping again. We haven't really got any handouts for this one. This is just a general Q&A, but if you want our contact details, they are in the handout button, which is on your GoToWebinar control panel. If you'd like to ask any questions or actually just have a general chat with Debbie and Maniva that are in the background making all the technical stuff work, then please feel free to do so. The question box is there, as is the chat box. The session is being recorded and will be available for playback. We're expecting to load it onto the website at the beginning of next week at the latest, but and you will also be asked as well just for some feedback on whether you found these sessions useful, and equally if you'd like to see us cover other topics in the future. Save the date, we will be doing our final set of webinars on the 9th of December. We're expecting some updates in a lot of different areas. One of them may well be the GDPR. There's some changes for those that are following the situation. We've got a new commissioner that's joining or moving to the UK from New Zealand, I think, Anna, isn't he? He's moving from New Zealand to join us. And we're also expecting as well some other legislation updates and hopefully opportunities in the ESG space. For those that have never met Risk Evolves before, what do we do? Well, we're a company that likes to help businesses be more resilient through effective risk management. So we do that in a number of different ways, 2 of which are looking at data privacy and information security being the other side of the data privacy coin. So without further ado, I'm just going to open the floor to anybody that's got any questions in this space. It's quite a busy area at the moment. And whilst we're waiting for the questions to come through, I thought it'd be worthwhile just talking to Anna and to Andy about some of the changes, because whilst this legislation came in, what, 3 years ago, just over 3 years ago, it's not stayed still, has it? Any comments,
definitely.
guys?
Yes, I mean, in terms of the one that jumps out is, I remember, Helen, when we chatted when I first joined and GDPR was going live, around what's the biggest challenge for most businesses, and is around supplier risk. It was the risk of suppliers processing your data, and it's probably taken for a little while for that to gather some legs. But obviously, with all the issues around international data transfers and the issues that came out with USA last year around USA not being deemed as a safe territory, it's thrown it all up in the air. And whether you're in the UK, the EU, or outside of those territories, around what it means to transfer data and is it safe or not. So that supplier risk is a massive area that most of the time I now spend with clients is helping them understand to make sure they're doing what they need to do.
Completely agree, and again, that was challenged in the courts last year, in the European courts, wasn't it, with the change of Privacy Shield and the European courts saying no, Privacy Shield is not a robust transfer mechanism for transferring data from the UK or even from the EU to the US. So that's all been thrown up in the air, hasn't it? And as you say, data transfers is very much on the Information Commissioner's radar at the moment. Anna, what about you? What do you think is some of the areas that we should all be focusing on?
I think just one of the things I think that has been one of the biggest changes since the GDPR is the B word, Brexit. I think that's Andy. I can see you smiling there. I think that that's certainly throwing up and will throw up some quite interesting changes as we move forward. And I don't know how many of you are aware, there's actually been a consultation put out, hasn't there, recently by DCMS to talk about how they may want to move away from some of the more challenging areas of the GDPR. And that's another consultation that's going on right now with the DCMS. So I think it's going to be quite interesting to see, Brexit has already seen some changes in terms of, we've now got our own version of the GDPR, the UK GDPR, but I think we're going to see some movement coming in certainly in the next few months and 12 months as we start to see what DCMS wants to do with our data protection laws.
Yeah, I was going to say, I was smiling to mention the B word with Brexit, and obviously since then we've had the C word with COVID. So is the D word now data? There's so much going on.
It is.
Are we going through the alphabet there?
No, we're not. We're not
going through the alphabet.
No. I know this is the last webinar of the day, but we're not going to do the alphabet. Right, so we've got a question from Mark, and I think, Mark, you're absolutely right. For many companies, this is something that we are struggling to stay on top of. So Mark says, like a lot of companies, we worked hard to understand GDPR and prepare for May 2018. But since then, we've done little to keep on top of changes. What, if any, are the biggest changes or developments that we should be aware of? So Anna, I'll go to you first of all.
I think one of the tips I would give to you, Mark, is while there has been a few changes, I think what it would be useful to potentially focus on is look at what changes you've had within your organisation since then as well. So, for example, have you introduced any new systems that might need a data privacy impact assessment? So, as well as looking at what the external changes have been, maybe have a look at what your internal changes have been and how the GDPR would apply to those changes. Andy, what's your thinking?
Yeah, I think that's, most clients I'm working with at the moment, it's because what they did in 2018 would have been fully compliant, but because they've changed a supplier, for example, that would be a piece of software they're using, CRM system, and that has brought in other risks because that CRM platform they were using was processed and hosted in the EU. It's now processed in the USA. And that brings in all these risks that with some of the legislation we've already touched on. So certainly internally, the external bit, it's really just the focus that's coming in things like cookie legislation around the need to get valid or explicit consent for non-essential cookies, which I still have conversations with a number of website hosts that say, well, we're compliant because we're providing all the information. But if we're still not getting that explicit consent, then it's still not compliant with what's needed. And these things are all that have evolved or perceived or looked at differently since GDPR landed in 2018. And the other thing is, obviously, there's continually cases going through the courts that put a different perception on what was right. And a lot of people on the line are probably familiar with a legitimate interest, so it challenges whether a legitimate interest is okay. So there's been things like telephone recording, is that okay? And as you know, Helen, recently the Bradford factor, which is used by a lot of HR for monitoring staff sickness, that's been challenged as well. So Mark, your question is very valid, is that what you did in 2018, you can probably get big ticks for 70% of it, but that 30% is what could now be exposing you. So it is very much something you need to revisit and keep thinking about, well, has things changed? Are we doing it right?
And if I look at the Risk Evolves experience as well, Mark, there's greater awareness as well now of the GDPR, and we're seeing that coming from probably two distinct groups. So we're seeing that coming from the data subject, we're seeing that coming from the individuals. So we have seen this year more subject access requests that we've helped companies with than we saw in the whole of last year. We saw in the whole of last year sorry, in the last 6 months of last year, more than we'd seen in the previous year. So subject access requests which are coming in from employees, most of them are absolutely legitimate when they're trying to understand what's gone wrong with the relationship with an organisation, are absolutely on the increase. And we are seeing organisations unfortunately being ill prepared for those, not understanding where their data is, not understanding why they've got it, not using it appropriately, sharing it inappropriately. And I will say as well, so because a subject access request means that you have to provide a copy of all personal data that you may hold on an employee, individuals possibly not doing quite the right thing with data and talking about individuals in a way which is inappropriate. The other side as well of that awareness is we are absolutely seeing more of a compensation claim culture. So as an example, there was a breach by one of the high street retailers a few months ago, and I started getting word of it through because one of the team had actually said, I've just got this email from whatever the retailer's name was saying they've had a data breach. I didn't go to the retailer's website to understand whether or not that breach was actual or whether it was just hype. I went to one of the solicitors that seeks compensation for individuals that have suffered data breaches to see whether or not there was any fuel, if you like, to the fire of this breach. And sure enough, on the front page of their website, they were saying, have you been a victim of whatever the company's name was, data breach? Would you like to join a group action to gain some compensation? And we've seen that play out in the courts. For those that followed the British Airways case, British Airways all over the news at the beginning of the year with ba.databreach.com advertising for people to sign up to the group action against BA, settled out of court. It was done under an NDA. I've heard various figures of between £1,000 and £2,500, £3,000 on payout for those individuals, and clearly we're just speculating on that. But there is a culture around if companies do not use data appropriately, then there may be consequences. Anna, anything else as I've been talking that's triggered in your mind there?
Well, I think it's quite interesting because two things, with yourself talking about the data breach and Andy mentioning third-party supplier risk. I think one of the interesting things there to bring those two together is if we talk a little bit about the case with Marriott. So the Marriott Hotel Group have had action against them for a breach that happened quite a while ago, and it's quite interesting because that brings the supplier risk really into focus, because that case was all around them, a third party that they had in part of their IT infrastructure where they hadn't necessarily done what they should have done. And it was quite an interesting case because they obviously Marriott were the data controller, and so they were held responsible for something that one of the suppliers should have done. So really interesting kind of divergence there of the third party risk and then the reach of the risk of the data protection claim from the data subject.
Yeah, and I guess something triggered. The other one was COVID, because obviously COVID itself, devastating for the impact it's had on everything, but actually as businesses now getting back to some normality around, well, can you test, can you keep the information? This is medical information which under GDPR is high risk. Well, can you, can't you, do we need consent? And obviously what seems to come out, the government is pushing us to do this, which actually contravenes data privacy. So there's sort of the two often conflict. So where obviously you mentioned, Anna, around risk assessments and having to do, this is the whole point of the GDPR, is to actually think about, well, do we think it's right, is it fair? And so COVID has been a massive challenge in many respects, including the data as well.
So Mark's asked us another question as well. So he says, we act for clients who are deemed to be controllers, whereas we are processors on their behalf. So for those that are not aware, there are two very distinct roles within the data privacy legislation. You are a controller, which very much determines how the data is going to be used, who it's going to be shared with, where it's going to be stored, etc. And then you may engage a processor, or you may yourself be a processor, that will then process your data on the behalf of the controller. So Mark says, we frequently receive stars and have to gain consent from the controller to provide the information. This delays things. Should our agreement with our client provide for pre-approval to respond to these requests in order to protect their position and to the same degree ours? So Mark, I think this is an interesting one, because whenever we work on behalf of processors and clients, we would always send the response to a SAR back through the controller. We would never provide data directly to the data subject unless, as processors, unless the controller specifically asked us to do so. So I think there might be something that we could look at there in your SAR process that should clarify that. Under Article 28 requirements, you are, as a processor, obligated to support your data controller when responding to SARs. So that is a forgiven, it's part of your contractual, it's part of your legal obligations to do that. So I wouldn't expect you to have to go to the controller to gain consent to provide that information. Anna, I know you spend your life doing subject access requests, and you've got loads under your belt. Any thought on that?
Yeah, I mean, that's a great question, Mark. And subject access requests are such a tricky topic. I completely agree there with what Helen said. I think it's, maybe it would be useful to maybe revisit the contractual agreement that you have with the organisation. Article 28 of the UK GDPR talks quite explicitly about your obligations as a data processor and what needs to be built into that contract, and that it's that place that would then dictate how you approach it. But I agree with Helen. I said, the data controller has the obligation to respond to the subject access request, and your legal obligation is to support the controller in that. Whether that be by the provision of data, those kind of things. But, I think that relationship and that contract are probably crucial in this space.
Rachel's asked a brilliant question, and I love this question right at the end of the day, so I'm going to throw it over to Andy. Why is GDPR still such a talking point when the regulation has been in place for a few years? And how does it stay relevant in a world where data and technology change so quickly?
Yeah, no, great question, and I think that's the challenge that we say, which is why if you did stuff in 2018, you need to revisit, because everything is changing. In terms of the legislation itself, the principles that were determined under GDPR in 2018 and then endorsed through the Data Protection Act 2018 in the UK, which we now follow following Brexit, hasn't changed. I mean, pretty much most of what we do is still set in stone. The key principles are, if you're going to take data off a data subject, so if I take Helen's data and I'm going to use that information, I've got to be clear of what I'm going to do with it and how I'm going to keep it secure. That's pretty much the principles of what we're talking about. So in terms of legislation, it hasn't, but you've got all these nuances coming through around, and you say the involvement of technology. Well, a lot are now moving into cloud platforms, which brings in additional GDPR risks that you may not have had when you considered what you did in 2018, because a lot of businesses in 2018 would still be using servers based on their own premises. If you then move that data that you're storing and put it into a cloud platform, it's being held by somebody else. And it's all those kind of risks that go through. The principles of what you needed to do in themselves haven't changed. It's just down to determining where the data is being hosted, who's processing it, and all those kind of things. You then got, running alongside that, all the issues around, it's not just the technology itself that involves, that's introducing artificial intelligence and biometrics as terms of security measures. You've got the cyber threats that are running behind it that continue to evolve as well. So therefore, a lot of the technology we're doing to put things in place to try and protect data, on the dark side of that, you've got the hackers and the criminals trying to develop means to break all of these technologies as well, which is why whatever you're doing as a business, whatever you do today may not be right tomorrow, but the principles of what you need to meet for GDPR themselves haven't changed. You still need to keep analysing that and consider, well, what has changed? Are we still safe? Which goes back with Mark's question around, we did this in 2018. Yeah, what you do today may not be right tomorrow.
And Rachel, very sadly, we've had two cases where, there has been this week in the news where there have been very, very clear examples of significant breaches to what's called the rights and freedoms of individual under the GDPR. So unfortunately, as you've probably seen in the headlines, the MOD today have come out and said that they've had a breach, and similarly, was it the Foreign Office have also said they've had a breach. And these have been individuals who have provided support to the British forces whilst out in Afghanistan, and now are physically at risk as a result of that data breach. So GDPR absolutely has to continue to be a talking point. That's possibly an unusual and hopefully a rare example of where somebody's actions and accidental, one hopes it was accidental, sending you an email which had lots of people on open copy and not on blind copy or in a group has compromised absolutely the rights and freedoms of an individual. But also this is around trying to bring it back to, I guess, more day-to-day and items that are relevant to us. It's about us having control of our data. There's a key case that's going through the courts at the moment called Lloyd versus Google, and it's about the data belongs to us as individuals. Our data is personal to us, and if you link it back to the privacy regulations, for example, everybody's got the right to privacy, and data privacy is part of that. Where our data is then processed, and some of the automated functions that are out there, and therefore some of the automated processing that's out there that can make determinations about, I don't know, the adverts that we see, or in extreme cases, the job vacancies that we may see. That's one of the reasons why the GDPR is still relevant. It's our data, and therefore we should always have a say and a control of what happens to it.
Very
philosophical.
Yeah, I was with an analogy that if I borrowed something from my neighbour, I would probably treat what they've given me differently than I would treat my own stuff. And I'm saying I'm treating my own stuff in a negligent way, but I would be conscious that I'm only borrowing this. I've got this in trust, and that's exactly the same with what GDPR principles are talking about. You only ever take the information from people in trust. It's not yours. You can't do with it what you want. And this has been the biggest challenge with some of those cases you're talking about, is the companies, because they've got the information, want to make money, they can feel they can use it perhaps in ways that was never clear or never really defined. But for me, if it always work on the basis, I've been given this in trust, so therefore I've got to be respectful of what I do with it, how I use it, how I keep it secure. It is always, for me, helps in trying to decide what's right or wrong.
Yeah, I absolutely agree, Andy, because we had a session with James Squire earlier this afternoon. James Squire from Warwickshire Police. He was very clear. Cybercrime is the fastest growing crime in the UK, and sadly that's because criminals want to have access to information that's pertinent to the individual, whether it be personal information such as credit card information or other information that they can use. And James used the example of a ransomware attack, where a criminal was taking pieces of information from all sorts of different sources, such as social media, from LinkedIn and goodness knows where else, to build a picture that then allowed them to attack a company. And it can't be right, surely, that a company can be taken out of business because of one individual's nefarious gain of personal information. So, yeah, that's one of the things. Anna, what other thoughts have you got? What other things are we seeing on a regular basis that we're supporting clients with from Risk Evolves?
I think certainly one of the biggest areas we've already mentioned, which is subject access requests. I think also policy development. I think those policies that we all developed back in in 2018. I think it's quite interesting. There was a question there about why is things a talking point and how are things evolving. I think one of the things that's helping us all to evolve what we're doing and the advice that we're providing is the case law that we're seeing. When we did things back in 2018, we all interpreted things in the best way that we possibly could, because there was no case law to actually say, this is how you should apply it. So I think certainly one of the things that I use when I'm applying that advice and guidance is ensuring that we're kind of looking at that case law and ensuring that the things that we did and the things that our clients did back in 2018 and the interpretations that we made can still be applied in the same way. And if not, if there's some new case law to apply to change up what we're doing, that's certainly certainly informing the advice and guidance that I'm giving.
So Rachel's just asked, I think, which is another brilliant and very timely question, given that you've just mentioned as well, Anna, subject access request. So under the GDPR, one of the changes that was introduced with the new Data Protection Act was that there would be no charge for subject access requests. So Rachel's just asked, should a cost be brought back in to request a subject access request? Would that deter people from making phishing requests to organisations, which may be just there to disadvantage the organisation or to cause some pain to the organisation? What do you think, Andy?
I'm quite happy that we don't charge for it, because everyone's got that right to understand what's happening with the information. I guess with the intent with some of these requests is what that needs to be considered, and obviously the update we've come through GDPR and clarity that came out with the ICO. I can't remember exactly, but it talks about manifestly unfounded requests, which is malicious type requests. You've always had the right to refuse those. So there is always a means to be able to take into context the information you provided. But fundamentally, a subject access request said that if I've given you my information, using that example, I've taken something from my neighbour, they're entitled to know what they're doing with the data. So therefore, if I'm doing something that I shouldn't have been doing with that data, they're entitled to know that. And if that is in a subject access request because they're fishing for information for some kind of claim, ultimately it's going to be found out in some way, shape or form anyway. But if it is purely malicious, just to turn around and say, let's see what we can find, then there's means of defence through the exceptions. But to be, I'm quite happy that we don't get charged. I don't think the volumes we're seeing are probably the areas we see the most. I'm sure Anna, you're probably more able to comment on that. Would be perhaps ex-members of staff that are looking to make a claim because of the reasons that they may have left the business. Actual genuine requests from people where they put the data, I've not seen too many. So they tend to be those more contentious kind of things. But if people have done what they should have done and comply with to comply with the subject access request should be fairly straightforward. So therefore, I'm quite happy that there's no fees.
Anna, what are your thoughts?
I think I'm with Andy here. And, you know, talking as somebody who's got about 250 SARs under a belt, you know, the vast majority of those were genuine SARs. And the individual, you know, had a right to see that information. And I would be concerned, you know, going back to your point, Helen, data privacy is a human right, and we all have a human right to understand how we're being treated and how decisions are being made about us. So, you know, I would be concerned to see a fee being introduced. I think it's a very, very pertinent question from Rachel, because actually the DCMS are doing a consultation at the moment about potential changes to the law, and they are mooting. One of the proposals is to return the fee structure, you know, to return the ability to charge a fee. But I think we have to also remember and balance this with the fact that while subject access requests can feel, you know, quite there can be quite an emotive response to a subject access request by an organisation, fundamentally that individual is exercising one of their human rights. And we always have to concentrate on the request, not the, you know, we have to concentrate on the rights of the requester, not necessarily, you know, whatever else has gone on around it. So yeah, I'm with Andy on this one.
The other one's sorry, Helen.
No, I was going to say I agree with you. I agree with both.
It was only £10 that used to be charged, and I suppose the areas where it became more of a challenge is perhaps in some of those more public sector GP practices and that, where they would have perhaps seen the greater volume. I've got some sympathy there with the volumes they're doing, but again, if you've genuinely done your GDPR compliance right, to get a subject access request should be fairly straightforward to pull the information, so it shouldn't be a costly thing for the business to respond to. But
And I think, Andy, that goes to a good point in terms of data retention as well, doesn't it? You need to make sure that we've only got data on file for as long as we need it. You know, we've seen organisations that haven't been harvesting, managing their data. So when you end up with a complex request, which has got lots of information that's got to be responded, typically, because what we've seen is because they're holding on for information much longer than it needs to be held on to. So
I've seen a subject access request where there was faxes from 30 years ago. So yeah, you know, making sure that you have your data retention policy in place, but also that you're applying it in action means that when you get that subject access request, you know, there's not too much data to deal with.
No, I agree. So we've kind of spoken a little bit, and we've only got a couple of minutes left to go. If I ask each of you, what do you think there are opportunities associated with the GDPR? We kind of focused on the negatives in terms of how it may be a burden to organisations. Anna, do you think there's any opportunities for the GDPR and the PECA and the DPA and goodness knows what other pieces of regulation we've got in this space?
Hugely. And I think, you know, those of you who work, especially with the B2C environment, you know, and you're working with consumers, you know, and customers directly, I think it can become a massive selling point to be able to talk really proudly around what you're doing to protect them as individuals. When I talk about data protection, I actually don't like to talk about the word data protection. I like to talk about people protection. So what are you doing? It can become a really, really significant selling point for what you're doing as a business. So yeah, I've always been an advocate that there are huge opportunities around that as a selling point for you as an organisation.
Okay, Andy, what's your thoughts in terms of, is there opportunity and upside associated with being GDPR compliant?
Yeah, I mean, I think for most businesses, always want to be proud of the way you serve your clients, and you know, we're a family business. We like people to trust us what you're doing. Well, data is such an important area now, and it's one that you can easily stand out against competition, because if you're completely open, you're completely transparent, and you can demonstrate what you're doing to do stuff securely, why wouldn't people trust you? And in the realms of some of the issues here around, so everything you then gear up to turn around and build the procedures you've got in business to manage that come through in the way you then support your clients. So yeah, so it's one of those, if you're looking for a USP to actually demonstrate your GDPR compliance and your security measures to make sure that people give you their information is safe and secure, it's going to stand out against those that may have gone perhaps to a more tick box exercise, because you're always then left in doubt. Well, I'm not so sure that I trust this organisation, or it may come out because there's been a data breach or compromise where it's quite clear that they hadn't done some of the things they had to say. Yeah, I think that word prior, that word used around being proud, USP, there is a big advantage for those that take it seriously and continually demonstrate it.
So final question from Mark, because I'm conscious we're a weeny bit over time. Mark's asked, clearly 3.5 years is too long to revisit and review one's processes and procedures. Should this be an annual task? Andy, what's your thoughts?
Yeah, for me, it should be annual, or certainly some kind of periodic review. Because if you're genuinely going through the principle of every time you're going to make a change with a new supplier or whatever, you're going through the process, then arguably a lot of what you haven't done has changed. But in terms of keeping staff aware annually, reminding them of what's going on, bringing home some of those issues that you've seen around some of the breach incidents or challenges, yeah, so annually feels about right. And I think it was Rachel mentioned about there's so much changing, means that you're going to address or cover most of those problems that may have been encountered.
I agree. And Mark, just to add to that as well, Risk Evolves is certified to 2 standards in this space. So we're certified to IASME governance, which is a standard which is really applicable for smaller organisations. And if you were on the call earlier with James, you'd have heard us mentioning Cyber Essentials. So IASME governance covers aspects of Cyber Essentials. It covers all the Cyber Essentials, ISO 27001, which is the Information Security Management System standard, and also the GDPR. And that requires that annual review. So you go back and review everything that you've got in place for your management system. And Risk Evolves is also certified to ISO 27701. So again, one of the big ISO standards. And again, that requires an annual review as well. So on the basis that those are 2 kind of leading standards, I would absolutely recommend that annual review as well. So we've run a little bit over time. Many apologies for that. Hopefully you found this kind of short, very quick fire question and answer session useful. We will be doing exactly the same again on December the 9th. In the meantime, if you've got any questions, then obviously please reach out to myself, to Andy, or to Anna with any questions. We're quite a friendly, slightly geeky bunch of people who just love everything about governance, risk and compliance. So thanks ever so much for joining us, guys, and hope to catch up soon. Thank you.
Thanks, everybody. Bye.